Thank you, Evan. It's Olivier speaking. Just 1 minute for the last people to jump in. I know that I'm often one of these people that just arrives on the top of the hour exactly. I see quite a few people currently waiting, queuing up to be in the room. It's great to see a good turnout today.
Indeed. Thank you, Olivier. Will do. And Olivia, by the way, Pierre, one of our presenters, has not yet joined, but we will message him to try and get a hold of him. Just
okay,
FYI.
Thank you. Thanks for this. All right. I see it's nearly 2 minutes past the top of the hour. There are quite a few people queuing up. So perhaps is it time now to start the recording and start the call. We've got 90 minutes today. So.
Sounds good. Thank you very much, Olivier. Good morning, good afternoon, and good evening, everyone, and welcome to today's call, the EURALA webinar on General Data Protection Regulation, GDPR, on Monday, 19th February 2018, from 1900 to 2030 UTC. And just as a reminder, we will not be doing roll call today as it's a webinar, but if I could please remind all participants on the phone bridge as well as computers to mute your speakers and microphones when not speaking. And please don't forget to state your name for speaking, before speaking, not only for the transcript, but also for the real-time transcription purposes. And also at the end of the call, we will be having a user experience part, which will be a several questions survey. We'll change the AC room format in order for everyone to answer the survey. It'll take about 5 minutes to complete. Thanks so much, and back over to you, Olivier. Please begin.
Thank you. Thank you very much, Evan. My name is Olivier Crépin-Leblanc for the transcript record, and I'm the chair of the European at-large organization, EURALO. We've got a webinar today that is, thancfully, was quite widely broadcast and publicized, so we have a good turnout for this webinar. We also have a scribe captioning pod that should provide for immediate transcription of what we are saying. And so one of the things that I would ask when people do speak afterwards is to identify themselves when they start so as to be able to have good, reliable transcripts on today's session. The idea for a webinar on GDPR is something that you might not see as being very original at the moment. There are quite a few webinars that we've seen over the past few weeks, and no doubt we are going to see further webinars on this topic in the forthcoming weeks and perhaps even months. The regulation itself was passed a while ago, but the enforcement date as listed on the European Union's GDPR, eugdpr.org website, enforcement date seems to be the 25th of May 2018. So we really are looking at the final countdown before things started getting enforced. No doubt Thomas Rickert from the ECHO Internet Industry Association will be able to provide us with a good update on this and perhaps even a view from the registrants or an organization, commercial organization's point of view as a whole. We have also Pierre Bonis from the AFNIC.fr registry, that's the country top-level domain for France, and he'll be able to provide us with some details and perhaps a perspective from a CCTLD, country code top-level domain points of view. Michele Nelen is also joining us on the call today. He runs Black Knight Solutions, hosting, co-location, and domains a long-standing ICANN participant and very active in the generic name supporting organization. And he will be providing us with a perspective from a European registrar and business point of view. In fact, Michele has been very active in complaining to ICANN about some of the problems of ICANN's contracts over the years, with ICANN not doing very much in response, or perhaps he will be able to provide us with a bit of insight in this. But certainly European registrars are probably the first affected, or the most affected of all the registrars out there. And then we have Athena Fracoli from RIPE NCC, RIPE Network Coordination Center. The RIPE NCC is the European Regional Internet Registry. A regional Internet Registry is the distributor of Internet protocol addresses, IP addresses. And of course, whoever says registry also means running a very, very large database. So the idea for such a webinar, as I said, there's so many other webinars on GDPR recently. The idea for such a webinar on practical implementation of GDPR from all of these different perspectives came from a sort of side brainstorming session that several of us had, several of us as being people from the members and also members of the board of Uralo, had during the Internet Governance Forum event in Geneva late last year, and there was an Internet Society party that took place. We all had a glass in our hand, and we started thinking about what Uralo could do to really help in various topics. And GDPR was the first one that came on the table. And the idea was to say, well, look, we've got all these theories and all this thing about what is the GDPR and how is it likely to affect people and so on, but very little of the actual practical implementation. What does it mean on the ground? As we all know, in theory, theory is the same as practice. In practice, it is not. So now that we know that we're in for an interesting ride, I'm looking forward to hear from everyone on the call here. I think there's somebody who needs to mute themselves, perhaps in the meantime. But anyway, I don't want to ramble on for too long. You've not come here to listen to me. You've come here to listen to our four panelists, and so I'm extremely pleased to be introducing Thomas Rickert to you, and to hand the baton over to Thomas, who I understand has got a small presentation for all of us. So Thomas Rickert, you have the floor. Thank you.
Thank you very much, Olivier. This is Thomas Rickert speaking, representing ECO, an Internet Industry Association with more than 1,000 members from 70 countries around the world. And we've been quite active in the GDPR discussion. As you may or may not know, ICANN has been quite silent on this topic. They haven't really suggested how the GDPR topic can be tackled, and then ECO stepped forward and came up with a data model that could be applied to the GTLD space. And I have to say two things as a word of caution. I have a little bit of a cold, so I hope that my voice is not going to let me down. So if I start coughing, then I think the next speaker should just take over. But other than that, and that's my second point, it's 8 p.m. in my time zone, and could there be any better way to spend an evening than talking about legal stuff and the GDPR? So let's dive just right into it. I should say that, and you will have noted from the agenda, that we changed the speaking order, because I'm going to introduce very superficially, very briefly to you, some of the main ideas, some of the basic principles of the GDPR, which are applicable to everyone. But then you will hear Pierre from .fr, from AFNIC, and then you will hear Athena from RIPE. And there's, a little bit of caution to be applied, because what's true for the GTLD world is not necessarily true for the CCTLD world or a database of IP addresses, because the policy setup, the contractual setup is completely different, or, it can be completely different, and that can lead to a different legal assessment and different impact of the GDPR. So Olivier mentioned this earlier, but just to recap, it will kick in, the GDPR, that is, on the 25th of May, and it will enter into force there, but on the 25th, it has already been published 2 years back, so it's not really news, and it will be immediately applicable from that day. There are folks who are confusing the concepts of directives and regulations, and while regulations have immediate effect, directives have to be transformed into national law. So that's one of the major distinctions. So after May 25th, we should all be compliant. The goal of the GDPR is to regulate data protection in a uniform manner throughout the EU, to give EU citizens better control over their personal data, and regulate how controllers may use personal data. On the other hand, shall ensure free flow of data within the EU and to regulate the export of personal data outside the EU. Now that tells us quite some concepts which are in the GDPR. First of all, it's personal data. So if you are an individual, if you are registering a domain name, GDPR will kick in immediately. If you are a company, then you need to be a little bit more cautious, because while a lot of folks, even particularly outside the EU, think that corporate data can never be personally identifiable data, that is not true. Corporate data, company names, can be PII, as we call it, personal identifiable data, if it allows for the identification of an individual. And therefore, just opening up two buckets, one for private users and one for company users, doesn't do the trick. And therefore, there is are some issues, and this is why we have suggested that all data should be treated the same in order to avoid the risk of corporate data, which actually is personal data being publicized without having a legal basis for it. Now let's look at some of the main themes. There are increased transparency requirements. That's important to users. You as a user, as a registrant, need to be told exactly what's going to happen with your data. So there are documentation requirements, information requirements, and the operators need to be able to prove how they stored the data and what they did with it. There are increased data security requirements for operators. There are increased accountability requirements, such as to report certain data breaches. There is the right to be forgotten. So you can say to an operator that you don't want them to have your data anymore, and then they actually have to delete it. Certainly this will be overridden where there are statutory archiving provisions, for example. So it doesn't, your data will not necessarily go away entirely, but a legal basis is needed for the data to be retained. There is the right to data portability, and then we have two concepts: privacy by default, which means that all systems need to be set so that they have minimum impact on your data protection. So no pre-ticked boxes for consent and other things, but you have to set the settings and make them less harsh than they are at the beginning. Then privacy by design means that you need to build your systems so that they actually comply with the principle of data minimization, so that no more data is collected and processed than actually required to fulfill a contractual purpose or within the boundaries of another legal basis. So to sum this up, you as a registrant have certain rights with this or based on this. You can actually go to a registrar or where the registry has your data and go ask them what data they have about you. And you can ask them to rectify your data, and if they're doing something wrong, you can try to get relief for that, and you can go to the authorities and complain about an operator. And if the authority doesn't take action, then actually you can take the authority to court for inaction. And that leads to sort of what some call a vicious circle, whereby even if the operators do not get compliant in time, suddenly users can go and sort of force the authorities to take action against the operators. Let's try to familiarize ourselves with some principles of lawful processing. First of which is consent. So if there is the free will by a data subject to consent to processing of data, that's perfectly possible to use as a legal basis. But this consent has to be informed, and it must be freely given. So there is the so-called prohibition of bundling, according to which an operator, a registrar, can't tell you, you can only have a domain name if you consent to the publication of your data via public rules directories. So that would be wrong. This is why we don't focus on consent-based processing, although it is possible. You can, however, do what's required to be done to perform a contract. So my typical example is if you are an online bookshop, certainly you need to know to what address to ship the book. So you can have it, have the data to fulfill the contract. Then performance to comply with the legal obligation. So if law enforcement authorities that are in your jurisdiction ask you for disclosing data, then you have to fulfill, you can reveal data to comply with the legal obligation to disclose data. Then let's move to the next slide. Then there's processing in the public interest. But for that to happen, you need to really have an official authority, or you must have been vested with a public function. And the European Commission has now mentioned the 6.1e, but they have not really specified that data can be processed by ICANN having this public mandate, if you wish. So that's something that we need to drill down on and ask the authorities to provide some guidance on. And then the last one is legitimate interest. So if you think you have a legitimate interest to process data, and that can be to reveal it to the authorities, to law enforcement, to IP lawyers and others, then what happens is that you can't just do it. You have to think carefully about whether the legitimate interest is present or not. And if you think you have that legitimate interest, then the data subject can still say, okay, but I think that my interest in keeping my data protected outweighs the legitimate interest of the controller. And then you start, you know, when such objection comes in, then you need to start a balancing act. And at the moment, the GAC as well as the European Commission are asking to keep the WHOIS as open as possible, and keeping it open or more or less open or create little hurdles would automatically lead to the notion that the legitimate interests of IP lawyers, governments would always outweigh the rights of the data subject. And I'm not saying that this is perfectly impossible, but we need guidance from the authorities to help with this. I will be done in a moment, but this chart shall just show you the complexity of contractual relationships that we're working with in the GTLD world. So you have a registrant either registering through a reseller or directly with the registrar. Then the registrar transmits data to the registry. Then in case of registry failure, you have the emergency backend operator, which you see at the far right of the slide, the eBureau, that can get access to data. You have different escrow agents for registries and registrars. Then you have ICANN prescribing the processing of certain data. And you have WHOIS customers that want to get access to that data. And all these processing steps need to be analyzed. And at the moment, and I'm sure that Michele will join me in saying so, at the moment, ICANN has not yet come up with a robust explanation of the legal argumentation, the legal grounds for all this processing that is required. And we hope to have contributed to this discussion with our, as we call it, ICANN GDPR Domain Industry Playbook, which you can find amongst the community proposals on ICANN's website. But I think what we should expect probably is that the current collection of data, collecting registrant data, admin C data, tech C data, billing C data, might not be compliant with the principle of data minimization. So it is possible that registries who, for example, have local presence requirements or other eligibility requirements might need that data, but then they would need to say so, while for normal domain registrations, you might only need the registrant. So we might not see that much of an admin C, tech C, or billing C, particularly since research of registrars has shown that in more than 90% of the cases, the registrant data is identical to the other role contact data. So expect some changes at that front. I think I should pause here, and I'm happy to answer questions when it comes to the discussion part of this call. Thank you.
Thank you very much, Thomas. Olivier Crépin-Leblond speaking, and thank you for respecting your time and going pretty quickly through the slides, but certainly a particularly exciting time that we're going through at the moment. You mentioned Pierre Bonis and the country code top-level domain operator, a CCTLD. Well, Pierre is running AFNIC, the .fr registry, and he's now next in line to tell us about the GDPR from a European country code top-level domain operator's point of view. Pierre, welcome, and you have the floor.
Oh, hello, thank you very much, Olivier. Do you hear me well? Hope
very
so.
well indeed.
Okay, thank you.
As they say.
So first of all, thank you, Olivier, and big thanks to Alex who have organized this this webinar. I think it's very useful, and I'm very happy to participate. I'm going to go through very quickly the first. I mean, I have two small presentations. One that is dedicated more to the ICANN context, and the other one to the FR context. Because as you said, I'm here. I'm here as the CEO of a CCTLD, but we are also involved in the ICANN discussions, not only through the CCNSO, but because AFNIC is also running some, as a backend registry, some GTLDs. So I'm not going to go through what Thomas has explained very brilliantly before about the main principles of the GDPR, and I will go directly to. I'm not going to go to the consent because it has been said before, and to the access, but to the personal data disclosure. The funny thing is that today a lot of players within the ICANN ecosystem are upset, or let's say they fear that being compliant with the GDPR is going to make a huge difference for them, and they will have to work a lot on their own information system to make it compliant. That's funny because we did exactly the contrary. When we started trying to be a backend registry for GTLDs, it would have been much more simpler to copy the .fr system to the GTLDs, but we didn't have the right to do it because by contract with ICANN at this time, and today at the moment where I speak also, it was not possible to be compliant with the personal data protection laws. So we had to work on an alternative system from the .fr we were running for more than 20 years. And we did it, so I'm very sure that the big players around the big registries will be able to do it also. I think there is a necessity to implement the GDPR in a standard fashion, and I'm sure that Michele will agree on that. So we don't have different solutions from different registries, but at the end of the day, the developments that are needed are not so huge from our point of view. So the main thing to me and to AFNIC is, as you understood, not really the change in the system that we have to do. To us, the change in the system is fairly simple. It's just hiding the personal data from the natural users. And maybe referring to what Thomas said before, we think, and our interpretation that has been checked with the French Data Protection Authority, is that the personal data that is sent by an enterprise may be personal data, but it's in the remits of the business. It's not in the remits of the registry, which means that when you talk about data that are not from natural persons, they are not covered by the GDPR. So at the end of the day, what do we hide? And what do we have to hide from public availability? The name, the first name, the surname, and the address, and the telephone number, and everything that is strictly a personal data. This is very simple to do that technically. What is not simple on the paper is to make sure that once you have done that, you still have the opportunity to give access to this data to people with legitimate interest. And I may say that we haven't got an automatic solution for that, but we have done that in the .fr since more than 10 years now, manually. .fr is more than 3 million domain names, so it's not a very big extension, but it's not a small one. For those who are not very familiar with France, you should know also that we have a very strong IP industry in France and a very strong industry linked with luxury products. So they are very interested usually in trying to fight the cybercrime. And we have an average of a little bit more than 400 requests per year that are all checked manually. And this is done by one woman who is not doing that all day, of course, and who is doing a lot of other things than that. So we think that the manual approach to asking for accessing to personal data is a good approach. And we think that the important thing is to explain that accessing to the personal data of a registrant is something that cannot be automated because it's in a way restricting the right of the registrant itself. So you must have a good reason to access personal data that, however, you should not have to access. So I don't know how it can be automated, and if it is automated, in a way you weaken the rights of the registrant, and the GDPR is all about enhancing the rights of the registrant and not weaken it. So we have some other issues that we have not exactly found the solution for now. It's the period of retention of the personal data. Of course, if the domain is active, as long as the domain is active, the retention should be okay. But how long do we retain the old data of an active domain name? This is something that is not very clear for us. The escrow data, what do we have to do with our suppliers of escrow, which I remind you is an obligation of the ICANN contract. So these things are not perfectly clear now to us as a backend registry and also as a CCTLD registry, because of course the retention is an important thing for a CCTLD, and the escrow is a good practice that is used also by the .fr. So that's why I say that the impacts are somehow more on this kind of gray part of the GDPR than on the bright part that is obvious, just hide the personal data in the GUIs, and that should be enough at the very beginning. Well, that was the first part of the presentation. Maybe I'm not going through the FR part of the presentation now because I'm going to be too long, but I just wanted to share something with you, and especially because as users, I think in ALAC and also as stakeholders in the ICANN system, you may wonder if there is going to be different way of implementing the GDPR. We all know that the ICANN management, the ICANN leadership has offered 3 models for discussions. It's a little bit unclear for us if these models have to be implemented, of this model, if one is chosen, has to be implemented before May. It's a little bit unclear to us if this obligation is compatible with the current contract that ICANN has with registrars and registries. Nevertheless, even if it's a little bit, I mean, we are a little bit puzzled by but what we understand, which is there is a model that has to be implemented in less than 3 months, and we don't believe that this is something that is compliant with the ICANN rules. The idea behind that, we think, is that ICANN tries to make sure that there will be a global solution for handling the GDPR, and that will be easier for the registrants to understand their right, whether they are on the .com.fr or .paris. And it will be easier also for the registrars to deal with it. But I have to share a last point with you, is that the GDPR is implemented. Of course, it's a basic set of rules, so it applies the same way in all the European countries. But at the same time, the personal data protection laws that has been passed before the GDPR has inspired some laws that are related to the CCTLD registries. Not all of them, but most of the CCTLD registries operate under national laws, and sometimes these laws have specified some very, very precise things about the protection of the data of the personal data. And as long as these laws have not changed, the way that the GDPR is going to be implemented by various CCTLDs, for instance, may be different from one CCTLD to another. And I will end with that. The model that AFNIC is not promoting, but the model that AFNIC is working on is compliant, of course, with the French laws that stipulates very clearly that the registrars are responsible for their data and the registry is responsible for his, which means that we are in a model where registrars are data responsible, registry is data responsible, and there is not a contractor or a subcontractor model that may be used by some other CCTLDs or may be used also in the ICANN model, which means that the diversity of the model is not going to end in the blink of an eye in May. We will still have some differences in the way we implement this GDPR, or at least this is what I expect. And at the end of the day, the diversity of the implementation, as long as all the implementations are compliant with the law, reflects maybe the diversity of the TLDs themselves, the values they carry, and the countries sometimes they represent, and I don't think this is a bad thing. So I think with that I will finish my presentation and maybe allow more time for questions and answers. Thank you.
Thank you very much, Pierre. It's Olivier Crépin-Leblanc speaking, and should I say, vive la différence. It's quite a complex environment here, and certainly quite exciting. And where are we going, basically? But without any further ado, let's go over then to Michele Nelen, who is with Black Knight Solutions, hosting, colocation, and domains. He runs a registry and has for a registrar and has run a registrar for a great many years and has been very vocal on these issues. And so I hand the floor over directly to Michele.
Thanks, Olivier. Hopefully everybody can hear me okay. And if I speak too quickly, please let me know, as I'm Irish and I have an awful habit of speaking at about a mile a minute. So I'm not going to spend too much time talking about who is and the ICANN piece, because the other panelists have spent a lot of time talking about that. The perspective I bring on this is slightly different. I'm looking at this more from the kind of approach of a company that operates online and needs to deal with GDPR across all lines of our business. So I mean, if you look at the first slide there, you can see, I mean, obviously it's promotional. You know, we offer domain names, we offer hosting, we offer email, we also provide connectivity for businesses. We've recently branched out into offering connectivity to businesses in terms of like DSL lines and all those kind of things. We offer digital certificates, and each and every single one of those things has to be dealt with in light of GDPR. So if you look at the next slide, I mean, you all have control there. So what we've been doing over the last about 12 months or so is going through all of our internal systems, our internal policies, our processes, and trying to work out, first off, exactly what data we have, why we have it, and do we actually need to have it. So for example, any business will probably have employees. In our case, we've got about 40 or so. We've been in business for 15 plus years, so over that time, we've had employees who've left the company. And as we kind of went through this entire process, you know, we discovered that we had information about former employees. And as other speakers have mentioned, you know, you do need to keep certain information for regulatory reasons. In the case of former employees, for example, we are often contacted by people, you know, asking us to confirm that somebody did actually work for us. But we discovered we had way too much data. We had information related to former employees that was no longer pertinent, and we'd no reason to keep it. So, you know, we dumped that. But when we're looking across the rest of the business, again, we're looking at it in terms of where are we collecting information? What information are we collecting it? Are we collecting? Why are we collecting it? Do we need a reason to collect it? Look, I'm not a lawyer. I'm not going to talk about various citations and everything within the legislation. But essentially the way we've looked at it is one of following the data and just trying to see if we actually need it. Because from our perspective in terms of risk, and that ultimately as a business is what we're interested in, what we're trying to do is trying to work out where the risks are and try to both document them and then address them as best we can. Both Thomas and I think Thomas did mention about you know, corporates. When you're dealing with corporates, that can also involve personal information. In our case, we have that going both ways. So, for example, if we have a company who signs up to us to our services, you know, we have a contract with the company, but in the course of doing business with companies, we will end up collecting information related to their employees. We end up sometimes with mobile phone numbers, we'll end up with email addresses, and sometimes, you know, that information is no longer needed. So we have to work out a way of seeing, first off, what we have, and then secondly, how we deal with it. Looking across the full range of products and services that a company such as ourselves offer, we've been going through it in terms of trying to work out, you know, as I said, which risks exist, where they exist, and what can we do about them. So if you look at the slide there, I'm talking about mapping risks. there's a difference between a risk that is known and a risk that is controlled. I mean, I might know about a risk, but it might be outside my control, which of course makes things quite difficult. Then, looking at it in terms of timelines, as has been said by the other speakers, GDPR comes into effect on May 25th, 2018. Being realistic about it, I know that most of us will do our best to be compliant by May 25th, but there are going to be areas where we know we probably won't be fully compliant. And sometimes comes down to us relying on a third party to, update their processes, update their documentation, et cetera, et cetera. I mean, it's not a simple, straightforward matter of us deciding by ourselves in isolation how we're going to address it. So as a hosting provider, one of the big issues for us is around responsibility for data. We have lots of physical servers, and depending on the service that is being offered from the servers, the responsibility will change. So if you look on the last slide, it's a draft at the moment, subject to change. You'll see we've put together a kind of draft responsibility matrix, which is just kind of helping us to work out, okay, which bits of data are things that we as a company should be in charge of. In other words, that we have that responsibility. Which bits really lie with our customers, our clients, and which bits, could be what we might call a shared responsibility. So to give you a concrete example, we provide email services on servers located physically in Ireland. We give people access to email addresses. They're able to log in. They're able to set things up. Obviously, we're going to look after the physical security of the servers. We're going to make sure that they are running up-to-date software. The servers, the software, all of that is not susceptible to, attacks of some kind. And, in a perfect world, DDoS can happen. In reality, it does. But ultimately, the users, they have the ability to change their passwords. So we cannot be held responsible if somebody either sets a very, very weak password or prints it out and sticks it on a Post-it note on their desk. Unfortunately, this happens. There's other cases where we provide a particular facility to a customer, but we have no ability to see what the customer is doing, and we don't want to know. As a hosting provider, we've been getting a lot of requests from companies, from clients of all shapes and sizes, asking us about, how we're dealing with all this compliance. And so, as I say, this is, where a lot of this came from. Again, it's draft, subject to change, but the idea being to kind of map out those responsibilities and see who should be looking after what. When we look at the overall risk and look at the percentage of our business that is linked to a risk, as a primary business is as a hosting provider. So let's just say, using kind of ballpark figures, well over half of the company's turnover is tied up in hosting. Domain names obviously are important to us, but it is a lower percentage. When I look then at the domain registries that we're interacting with, and these kind of interesting cross-border issues, that's when we start to run into some issues. We could go to town on all the issues surrounding how that works with ICANN, but in fact, in some respects, the bigger headaches aren't coming from ICANN. They're actually coming from some of the country code operators who are demanding very large amounts of personal information. So, for example, in some cases, you might be asked, as part of a domain registration, to provide not only proof of your physical address, but you might also be asked to show proof of your identity. And we have questions open with several domain registries around their handling of that data. So in terms of like the risk, that's something that does kind of keep me up at night. I think I've rabbited on quite a bit now, so I'll shut up and cede to Athena. Thank you.
Hello, everyone.
Can I be heard now? Hello? Okay, well, it looks like I can be heard now. Okay, thanks very much for this, Michele. Sorry, Adigo did mute everyone, and I wasn't quite sure whether I was muted or unmuted, but it looks like I'm now unmuted. It's Olivier Crépin-Leblanc speaking. Thanks for this, Michele. We'll go over to Athena Fraculi from the RIPE NCC, Réseau IP Européen, as they started their names, and that's the Regional Internet Registry IP addresses, a totally different angle, but equally challenging problem with the GDPR. Over to you, Athena.
Hello, Olivier, and thank you very much for pronouncing our name with the right accent and the right way. Hello, everyone. This is Athena Fraguli. I'm head of legal of RIPE NCC. Well, I'm going to give you our perspective on the implementation of the GDPR. We all know, well, my co-speakers talked about it, has been adopted in April 2017. It's replacing the already existing EU Data Protection Directive, and it will come into effect in May 2018. Before I talk about the implementation of the GDPR, I would like to give you some background information about the RIPE NCC. The RIPE NCC is a non-for-profit organization. It gets funded by its members. It's a membership-based organization. And it has given the mandate by the RIPE community to act as a registration authority of internet number resources, including IP addresses, in region of Europe, Middle East, and Central Asia. This registration authority includes, on the one hand, the operation of the publicly available RIPE database, which might be known to some of you as the WHOIS database, but we call it the RIPE database. And we also maintain some non-public registration information. This role is very important for the internet globally. It ensures the uniqueness of internet number resources that are useful to the public network, and this is essential for the proper function of the internet. Also, publishing this registration information in the RIPE database ensures transparency about the proper distribution of these internet number resources. And for a third reason, having the contact details of individuals that are responsible for specific internet number resources, it facilitates the internet coordination among them, and it is very crucial in case something goes wrong. So we understand the responsibility that comes with this role. That's why we are trying to enhance our accountability, which are to be accountable and to have a clear governance procedures for this role. Now, of course, the RIPE NCC is based in the Netherlands. So for us, the data protection legislation is nothing new. We are already covered by the EU Data Protection Directive. In 2006, also, the rights community saw the importance of having the RIPE database in compliance with the legislation. So it established a task force, the Data Protection Task Force, with a mandate to recommend steps for the implementation of the directive, and also to develop procedures with the RIPE NCC and the legal framework for the rightful processing of personal data in the RIPE database. The outcome of this work is published in this data protection report, and I give you the link to that. So next to that, the RIPE entity was involved in 2009 in the EU public consultation on the legal framework for the fundamental rights to the protection of personal data. And we actually responded to this public consultation. We submitted an opinion together with the RIPE community. In this opinion, we highlighted the importance of having the contact details of operators of the internet easily accessible to each other inside and outside the EU, because this is crucial for the proper functioning of the internet around the world. That was our statement. And this leads us to today, where we're preparing for the GDPR. Now we do have the regulations. And yes, of course, we feel that we've been always complying with data protection legislation, but it's always a good opportunity to have a review of all data sets we process and to make sure we comply with the new legislation. In March 2017, we established internally a big project about that. And we are reviewing since then all personal data we process. We have a project team that consists of 2 legal counsels and 2 security officers, and we get supported by our colleagues from all departments. It's a cross-departmental project. It's very big. We also engage with external legal counsels and our industry partners, and of course we want to be in contact with and communication with the RIPE community. We cannot change things without consultation with the RIPE community. So where are we so far? We have now a catalog of all data sets that are processed by the RIPE NCC, and we are reviewing this compliance with the GDPR. Our main areas of focus are for the RIPE database, the retention of personal data, our internal processes of all personal data, and other RIPE NCC services apart from the RIPE database. But today, and for this webinar, I'm going to talk a little bit about the RIPE database, which I believe is an area of high interest in this group. So when we talk about the RIPE database, we first need to look into the purpose of having personal data in the RIPE database. The purpose is essential for the legislation, for data protection legislation. When the RIPE community and the Data Protection Task Force, back then in 2006, looked into the matter of the RIPE database, they did define the purpose of having personal data in the RIPE database. And they described it in the RIPE database terms and conditions in Article 3. So, among others, the purpose includes facilitating coordination between network operators for network problem resolution, outage notification, etc. It is so crucial to have this public this information, this contact details publicly available. When, for example, we have like cyber attacks or issues that affect the operations of the internet, network operators need a quick contact, need to establish a quick contact amongst them. And these network operators have no other direct relation. They don't have a business relation. So the first thing they do is to look into the RIPE database and check who is responsible for the network that is involved in the problem. so it is, yes, that is the main purpose for us to have personal information in the right database. Of course, the legislation requires us to have a legal basis for that. We believe that the contact information of resource holders is, sorry, my slides are moving for a reason. So the legal basis when it comes to the contact information of the resource holders is the legitimate interest of the internet community. The internet community must know who is responsible for what IP addresses and what network, for those purposes I explained before. Of course, if the resource holder wants to delegate this responsibility, wants to delegate to someone else the responsibility of picking up the phone or to respond to emails for such purposes, of course they can have the contact details of another individual, but they must make sure they have the consent of this individual when it comes, for example, to their staff or to someone they have a business relationship. This can be obtained via this relevant relationship. And of course, if someone wants to have their personal data removed from the right database, there is a process for that, and we do facilitate that. But of course, every time contact details are removed, they must be replaced by the contact details of another individual that gives, of course, their consent for that. Also, we do implement safeguards. We have a limit to the maximum. We have a limit to the number of personal data queries in the RAP database, and these limits are defined in the acceptable use policy. And here is the link to this policy. So, as I said, it's very important for us to have a clear communication and consultation with the right community, and it's very important for us to be transparent and to show to everyone how we implemented GDPR. For these purposes, we have launched a series of RIPE Labs articles, which is a website we maintain, where we publish research and blogs and things like that. This is the link to the series of the articles about the GDPR. The new article will come this month, and it will be about, it will give a little bit more information about the legal basis of processing personal data, so stay tuned. And we also have a web page, of course, dedicated to the GDPR, and here is the link to that. And yeah, I think I made it just in time, and I'm ready for the discussion. Thank you.
That's great, Athena. Thank you very much. It's Olivier Crépin-Leblanc speaking, and we are indeed now finally reaching the point of our call. We have about 30 minutes, so just under 30 minutes, for questions and hopefully some answers, and for a good discussion to take place on these these four excellent presentations that we've seen today from the different angles. And whilst you were all doing your presentations, some questions did come in the chat, and indeed some answers also came. Now, in order to ask a question, you either type it in the chat or you put your hand up by using the little person with their hand up on your Adobe Connect. Make sure that your mic is connected, and I'll take the questions in the queue one after the other, and we'll have a mix between the questions in the chat and people who wish to ask their question by speaking to the microphone. Whilst people are gathering their thoughts after all this viable and exciting data that we've got in front of us, let me just ask a few of the questions that were asked. And in fact, the first one that came on the chat was one from Barack Otieno. And the question was, I'm keen to understand whether GDPR will only affect hosted data or if it affects data in transit as well. And Mathieu Camus immediately afterwards followed up and said, well, data in transit is concerned as well if and only if the processor of the transit is able to read and distinguish the data For example, telecom operators are not concerned unless deep packet inspection is used. But, adds Mathieu, telecom operators are also concerned if they can relate an internet, an IP, I guess, an IP address to an individual. So there are several levels on this, and I know that Barak Otieno followed up afterwards saying, well, a lot of the African traffic does go via Europe. So it's interesting to see that angle. I don't know if any of our panelists wish to add to this exchange. Otherwise, I'll go to the next question. Oh, okay, so then the next question was, going a bit further down, Ruben School asking if the panelists could entertain a question about informing the data subjects that their personal data has been accessed and by whom. Is this a good idea or is this a bad idea? And who wishes to answer this? Pierre Bonis.
Thank you, Olivier. Can you rephrase it a little bit, because I'm not sure I understand very well, but I think it's a very interesting question.
Thank you, Ruben. Sorry, Pierre. It's a question from Rubens, asking if it would be a good idea if, for example, you could inform the data subjects that their personal data has been accessed and by whom. So someone in the WHOIS database and that is told, your data has been accessed by such and such. Is this a good idea or is this a bad idea?
Yeah, okay, thank you. Very quickly, it's a very, very good question. Personally, I think it should be not only a good idea, but the minimum information you have to give to someone. The fact is that we are not doing that currently when we give access to the personal data to the .fr registrants, and especially because some public authorities don't want that the people are informed that they have access to their personal data. But I really think that this is something that we should change, and you should have a notification when your personal data is accessed by a third party. Even if we don't say who accessed, at least we should say someone has accessed. But this is my point of view.
Okay, thanks for this, Pierre. It's Olivier speaking. And it's funny to think that in cases of LinkedIn, for example, there is a list and it says, who has access to your record on LinkedIn. So that's an interesting thought, perhaps, on that. Thomas Rickard, you have something to add to this?
Yeah, thanks very much, Olivier. And since you mentioned LinkedIn and other business networks or social networks, they make it a contractual feature for the data to be traceable, right? So they want you to be able to see who saw your profile, and in many cases, the free version of the service does not allow for such tracking. So you have to pay for getting that additional information to find sales leads for yourself, for example. So if you can make it a contractual feature, then you would be covered by this clause 6.1b that I referenced to when I did my introductory presentation. But I wanted to give an answer that's not a legal answer, but a practical or political answer. When the GDPR was drafted, there was nobody thinking, at least as far as I'm concerned, about the needs of law enforcement, right? So when it comes to wiretapping or other areas where law enforcement get access to data, or if you take patent databases or trademark databases where information is made publicly available, and there's an analogy used to WHOIS many times these days. For these actions, you have a legal foundation, which seems to be having forgotten when the GDPR was drafted. And now the law enforcement authorities are waking up, and the governments are waking up, and they're very frightened that this valuable resource of information will not be accessible or not be so accessible so easily for them. And this is why they're making these calls about the WHOIS data to be in the public interest, that public policy objectives are being pursued with it, but that doesn't make a legal foundation. And so we're looking for the governments who want the data to be accessible to explain to us why or how we can make this work, right? So that's a little bit of a challenge, and the law enforcement authorities have even asked that any access to WHOIS data, may it be gated access or otherwise, should not be disclosed to the data subject in order not to have a detrimental impact on investigations. And there's a paper that was drafted under the auspices of the Bulgarian EU presidency with Europol. They explicitly state that WHOIS queries should not be traceable. You know, so that's the factual situation that we're facing. I think it's difficult to justify that legally, but since the governments want it, the governments have to explain to us how we can make it work without the contracted parties being at risk of being fined, or they need to come up with a legal basis, such as a law, to make that happen comparable to trademark databases.
Thanks very much for this, Thomas. I note next in the chat is a question from Eve Edelson from the San Francisco Bay ISOC chapter. And the question is with regards to the membership database that the Internet Society has. And we wonder how or if GDPR impacts info on membership, like mailing lists and maybe the need to repeat opt-in for this. Now, I've actually followed this on the Internet Society front. I know that the Association Management System, the AMS membership database that the Internet Society has of its members, is currently undergoing an opt-in test or a review where people, and I'm not sure whether it's only restricted to European chapters or whether it's actually worldwide chapters, but people are encouraged or are asked to confirm their membership and confirm their the ability to have their details in that database. So I don't know if anybody else has the answer to this question when it comes to whether this is a worldwide thing or just for the European chapters. But certainly the Internet Society is concerned with this too. Pierre, you still have your hand up. I don't know whether it's another answer that you wish to provide. No? Okay, you put the hand down. So then the next question is from Aidan Ferdelin, and it's a question for Athena. Disclosure to third parties for the purpose of building value-added services, policing cybercrime in the private sector, and defending intellectual property rights is not, strictly speaking, explicitly envisaged in ICANN's existing WHOIS policy, although it is implicit by the absence of a privacy policy that protects individual rights. If ICANN wishes to continue with this implicit policy based on RIPE's experience coming to understand the GDPR, what do you think that ICANN needs to do to legitimize this? And that's a question for Athena. And I think that your mic is not working, Athena, at the moment. I cannot hear it. I think we have a technical problem here, no? Okay, if I could ask staff to please check on Athena's line because I'm not hearing her. I hope I'm not the person who's dropped out of the call. I can certainly see myself being transcribed. So let's move to the next question in the meantime. Athena, unfortunately we can't hear you, so we'll check with staff. Perhaps your mic has become unplugged or something, or the connection Adobe Connect is sometimes notoriously a bit tricky. Next is a question from Jim Prendergast. Does GDPR only apply to European citizens living in the European Economic Activity Area, or does it apply to European citizens regardless of where they live? Michael Nalen was the fastest on the buzzer. You have the floor, Michael.
Thanks, Olivier. Michael, for the record, giving a completely non-lawyer answer. The territorial scope is specified in Article 3 of GDPR, and my understanding and interpretation of it is that it applies to anybody in the European Economic Area, whether they're a citizen or not is completely irrelevant. And it also refers to where the data is being processed. So, for example, if you were dealing with an American company who was processing the data within the EU, then GDPR would apply. If you were dealing with a European company who was processing the data anywhere in the world, then GDPR would apply. I don't know if that helps answer your question.
Thanks very much for this, Michele. Olivier speaking. So indeed, quite a wider scope. Ricardo Holmquist is the next question. Oh, I see Pierre Bonis, you have put your hand up as well to this question. So Pierre, do you have anything else to add?
I may differ a little bit. What is special about GDPR is that it changes the territoriality that was the basis of most of the rules of the EU to the customer location. It's not the location of the supplier, it's the location of the customer. So, of course, we are talking about EU citizens, but if an EU citizen is asking for a service while he is living in America, I think this is not applicable.
Thanks. Yeah. The next question, that's from Ricardo Holmquist. I read this week that in Spain, only 20% of the companies are prepared for GDPR. Any clue if this regulation enforcement could be delayed? And someone is using both the Adobe Connect and their phone. So they would need to mute. Thank you. So any clue if this regulation enforcement could be delayed? Now, there's one thing, though. The regulation has actually gone through. We're already in a kind of a moratorium time, aren't we? Thomas Rickett.
Yeah, thanks very much, Olivier. Thomas Rickett speaking. Now, the regulation will enter into force on May 25th. The Article 29 group, which is the group consisting of national data protection authorities, have stressed multiple times the independence of the supervisory authorities. So I guess there's no way to actually make them hold off with sanctioning. Although a moratorium, at least in Germany, has not been unprecedented, because at the time when the Safe Harbor Agreement was invalidated by the European Court of Justice, German DPAs have said, okay, we're not going to sanction before we get some more clarity on the succeeding agreement, because it would leave everyone standing in the rain, right? Yeah, I guess the situation is different and not different at the same time. It's different because GDPR is 1.5 years old. It's been out there. Everyone had time to prepare. I guess in the ICANN world, we're facing particular challenges because we had letters from the Article 29 group dating back to 2003, which have been more or less ignored. So I think expecting some grace period from them, would likely not go down very well. However, even the European Commission has now asked for more time to discuss. They've asked ICANN to postpone a decision on a compliance model until after ICANN 61 in Puerto Rico. So I think that you know, that would probably be something that we could use to say, okay, we didn't get any clarity, and even the Commission has asked for more time.
Thanks for this, Thomas. Now let's check if Athena Fraculi is back online now and is able to speak to us. Testing 1, 2, 3. Can we hear Athena? Unfortunately, I'm not able. It's *6, I think, to unmute.
Hello. Can you hear me now?
Ah, now we can hear you. Welcome back, Athena. So the question that was fired over to you was if ICANN, well, the whole thing about ICANN's existing WHOIS policy, although it is implicit by the absence of privacy policy that protects individual rights. If ICANN wishes to continue with this implicit policy based on RIPE's experience coming to understand the GDPR, what do you think that ICANN needs to do to legitimize this?
Yeah, thank you very much for the question. I'm afraid I'm not very familiar with ICANN's policy, so I cannot really comment on what ICANN does and how you know the process is there. But I can give you some insight on the way the LEA and national authorities requests are dealt by the RIPE NCC. So it's again in Article 3 of the RIPE database terms and conditions. It's defined in the purposes of the RIPE database that the purpose of the RIPE database includes also providing information about registrants and maintainers of internet number resources when the resources are suspected of being used for unlawful activities to parties that authorized under the law to receive such information. Also, another of the purposes of the RIPE database is providing information to parties involved in disputes over internet number resource registrations to parties who are authorized under the law to receive such information. So if contact details and personal data are already published in the RIPE database, then those that have the right to receive such information under the law can indeed use this information from the RIPE database as long as they're published. When it comes to non-published information, this we do not provide unless we have a Dutch authority order. I hope this explains a little bit the way we are dealing with such a situation. Thank you.
Thanks very much for this, Athena. Indeed, it looks like the RIPE has really given quite some thought onto this. Now, there was a follow-up question from Eva Dilson regarding ISOC HQ dealing with the databases of members, but what about at the chapter level? And I guess that somehow fits with the question of whether something as simple as a mailing list is subjected to GDPR. So many of our own organizations, at-large structures and others, and companies, in fact, run often databases or just a mailing list to inform our clients, our colleagues, our members of all sorts of information. Are mailing lists, something as simple as a mailing list, subjected to the GDPR? Who wishes to answer this one? Yeah, Bonis.
Yes, a mailing list is subjected to the GDPR, of course, but this is something you can do from the beginning. I mean, you don't have to ask, or I think you don't have to ask every time you're setting up a mailing list. You have to ask if the members agree to be opt-in as long as they are members when the association is putting a mailing list on. And at the end of the day, the compliance is just having a piece of text at the end saying, if you want to unsubscribe the mailing list, just let us know, which is something that Isaac does for years and years, and maybe for the beginning of the internet, because Isaac has invented the netiquette. So I'm not sure it's going to change the way Isaac is doing with his mailing lists. Just giving the opportunity for the people to opt out and asking for the opt-in when they sign for the membership.
Thanks, Pierre. Michele?
Thanks. I mean, look, I think some people seem to think that GDPR is, brand new, a whole new concept. And the reality is it isn't by any stretch of the imagination. As others have mentioned, it's based on pre-existing legislation. And on a practical level, when you're talking about mailing lists and email and how you handle that and all that kind of thing, it's something that if you were doing it right, it won't be an issue. I mean, does GDPR apply? Yes, of course it does. As long as you have permission from people and you respect that permission and you handle email in a fashion that is responsible and permission based, then you won't have problems. If for example I sign up for your mailing list to buy, I don't know, I'm interested in buying cleaning products, and then you start sending me email about coffee, then that's a problem. But that's always been the way, and if you want to make sure emails don't bounce, that's the way that you look after your email lists anyway. But to answer the question in short, yes. Thanks.
Thanks very much for this, Michele. It's Olivier speaking, and the next question that is listed in the chat is one from Javier Rua Jovet from the ELAC. And the question is, to anybody, does ICANN, under its bylaw obligations to take notice of international law and or human rights, consider protection of end users' privacy a legal obligation binding upon itself? Does it have any pertinence on the GDPR, RDS, and who is discussion? And I think that Javier mentioned a bit further down that he wished Thomas to try and take a stab at this one.
Yeah, I'm glad to do that. And hi, Javier. Looking forward to seeing you in Puerto Rico in a couple of weeks. Now, this is a tough one because the GAC, for example, has made explicit mentioning of ICANN's bylaws as a justification for making or for processing WHOIS data and making it available, because having WHOIS data is within ICANN's mandate. It is enshrined explicitly, it's hard-coded into ICANN's bylaws. Now the question is, what legal status do these bylaws have? And as I mentioned earlier, if it is the wish of international governments to vest ICANN with performing a public function, then potentially this stipulation in the bylaws can be used as a legal basis. But typically that would require a law or some other act of equipping a private entity with a public function. So we don't have that, and therefore I'm a little bit cautious to just jump to the conclusion and say it's in the bylaws and international laws are in the bylaws and therefore we can do everything via the bylaws. Because the issue is that we have this E, 61E, dealing with public interest, and then we have
and we appear to have
dealing with legitimate interest. The hurdles for E, processing of data in the public interest, and E, right? So this might be a little legalistic, but we really need the governments to help us here and how they construe the GDPR and whether we can make use of the bylaws either via 61E or 61F. F. So I hope that this answers at least superficially what you were asking for, but I'm happy to discuss more and maybe on site in Puerto Rico.
Thanks for this, Thomas. It's Olivier speaking. Unfortunately, we lost audio for 5 seconds. It maybe what might have been a crucial sentence where you said, but I'm happy to discuss, where you were saying that, where do we have it? Yes, the scrolling is difficult. Where you're saying that I'm just trying to see here.
Do you want me to take
the issue is that we have E6.1E dealing with public interest, and then we lost audio. Something for E. So just that last thing about the public interest.
6.1E is processing in the public interest, but that would typically require a law or an official vesting of the controller with a public function. And if the government think that ICANN is performing such public function, then potentially we could use the bylaws as a justification for dealing with data under 6.1E. The issue is, however, that if 6.1E is not applicable, the only route we could take on this is 6.1F, based on legitimate interests. And this is something that you read in the government's letters. So they're basically speaking of public interests, public policy objectives, and public benefits as legitimate interests. But if you could play those via 6.1F, with the hurdles for 6.1F being far lower than for 6.1E, then that begs the question why you need 6.1E in the first place. This is why I'm struggling systematically looking at GDPR of using 6.1E and the public interest for such purposes, or using the bylaws per se. But I guess the governments who've called this out as a solution should be more precise in helping us understand what they really mean. And yes, it's complex stuff. I agree.
On the live stream, because this webinar is being live streamed as well. There's a question from Shah Zahidor Rahman. And 2 questions actually, but we can probably take them both at the same time. How should companies approach GDPR from a management standpoint? How does the GDPR differ from existing data protection legislation? Who wishes to, Pierre Bonis.
Oh yeah, thank you. I would say a little bit like Michele said in his presentation. The change is not too much in terms of our core business, but it's a very big change in our internal organization. It means that we are dealing now with something that is closer to an ISO 27001 approach than to the previous one that was simple declaration that you are compliant. So it's a management system, and I think the difficulty for some businesses are the difficulty for the businesses that are not familiar with the management system and the implementation of the ISO or EFQM systems is going to be difficult, because at the end of the day, this is not true that we have to be 100% compliant in May, but this is true that we have to show that we are in a continual improvement and that we manage this improvement, and it implies a way of organizing things internally that is a bit difficult sometimes. So this is the main change, being able to follow the progress that you do and the risk assessment that you do on personal data, as before it was just you say what you do and if you are wrong, you may be punished. It's a huge difference, and for some SMEs, it's a huge challenge.
Thanks for this, Pierre. Next is Thomas.
Yeah, just to add to Pierre, I think companies who are in Europe and who have taken data protection laws seriously, they are probably in good shape, and there's not too much to do. So although you still need this data protection management or data security management system, which was required before, so there's some work to be done, but it's relatively easy, I should say, compared to, let's say, non-European operators who are processing data of European data subjects, because in certain cases you have completely different approaches to data protection in their respective home countries. If you look at the US versus Europe, this is really a clash of cultures in terms of data protection, and therefore, we're doing a lot of work in the area. I'm a lawyer working in private practice, and we see that we have to do a lot of explaining to convey the spirit of GDPR and how it differs from the US approach to data protection.
We're losing Thomas again. Briefly, Thomas, you.
Okay, I had finished in the meantime. I'm not sure to what.
If you can just say the last 30 seconds of what you were saying, please.
Okay, I apologize. I was saying that it's relatively easy for European operators that have previously been compliant with applicable data protection laws. But for companies outside Europe, you really have at times a clash of legal cultures. And that is difficult to inject into the company's common thinking, that you have to take an entirely different approach to data protection laws. And I guess the most prominent example of that is the difference between the US system and the European system. For those, it's much harder.
Okay, thanks very much for this, Thomas. And I'd like to take just another few seconds to thank all of you. So Thomas Rickard, Pierre Bonis, Michele Nelen, and Athena Francoli for providing us with this insight on practical implementation of GDPR. There's an exciting discussion going on in the chat as well, and I'd love to have the time to take us through the discussion that is going on, but unfortunately we kind of have run out of time. We could have gone for another at least 30 minutes on this. Time has flown. Don't leave quite now. There's still a real-time text, so real-time transcription survey. The box that you see in the middle of the screen